Good morning, everyone, and thanks for joining us this morning. This has been a very, it's very topical at the moment, this new legislation that's just been brought in by the Labor government, and there's been a lot of interest in it. We've got about 100 people registered. Now, we know that not everyone will turn up today because it is the week before Christmas after all, and we did encourage people just to register regardless, and we'll send you the recording afterwards. So just a little bit of housekeeping. I've put everyone on to mute. So if you're not on mute, if you can just keep yourself muted, that would be great. And if you can open up your chat box and just say hi and just make sure that you can see the presentation okay. And what we will be doing is just going through the presentation first, and then at the end we'll be taking Q&A. Okay, so if you do want to just pop in any questions that you have into the chat, into your chat window while we're going through, or make a note of it separately on a piece of paper, and then we can go through those at the end. Okay. All right, so let's kick off. Just very quick intros. Now, I think half of the people on here probably already know me and half don't. So I'm running this in conjunction with Greg and Margot from HR Success. I run a business coaching firm, and I've been doing that for about 17, 18 years, and generally working with established growing businesses that need help better managing their growth and looking at management systems. I'm a trained accountant, so the numbers are very important to me. And as you can see there, I specialize mainly in planning, productivity improvements, team performance, and profit improvement in general. I'd like to hand over to Greg, who's going to introduce himself and then kick on with the webinar and the presentation.
Thank you, Anil, and good morning, everybody. It's great to see you all here. 5 of you at a time on my little screen here, but thanks for joining us today. And introduce also my colleague Margot. So Margot's with us today. Margot will be chiming in when I fumble or get it wrong, or to add a bit of colour to the discussion today, and certainly to help out with the Q&A stuff. So thank you for being with us, Margot. So just very quickly, I think a lot of people on the call I've had the joy of meeting before, but for those that I haven't, HR Success, we're based in Western Sydney, in Penrith. We've been established for over 15 years now. We basically provide recruitment and HR support to small to medium-sized businesses. Predominant number of our clients are local to sort of Penrith, Nepean, Blue Mountains, Western Sydney. We don't do retainers or lock-in contracts. We just provide support as and when people need it, and we rely on the quality of our service to keep our clients. We're a small team. There's only 3 of us. So Sam's off on holidays this week, so she's not joining us, but we're a small team, so you always know who you're dealing with. And we have a combined experience of over 60 years, which sounds a hell of a lot. Feels a lot too sometimes, but in HR and helping businesses, organisations manage their people stuff. So that's a little bit about us. Thanks, Anil. Okay, so I'll move through the bulk of the presentation. As I said, Margot will chime in when I'm running a bit off track, and Neil will chime in if we're running a bit short on time. We do have a lot of material to cover. These are significant changes. These are the most significant changes to workplace relations in Australia since the introduction of Fair Work in 2009. So there is a lot going on at the moment. There's a lot that is unclear. So it'll be early next year before we get some detail on some of these things. So we'll provide the detail where we can. However, we may need to do another webinar or something in the new year to pick up on some of the details, because the changes are being staged over the next 12 months. So we'll focus today particularly on the changes that are happening now, and we'll highlight those changes that are likely to come next year. And then, as I say, we'll provide more information as further detail comes out. Certainly we'll do our best to answer any questions that come through the presentation today. And If we can't answer you, we will take your details, obviously, and try and get back to you with an answer over the next coming days. Just what they call that, a disclaimer of sorts. This is not formal or legal advice. We're not equipped to provide you with legal advice. We do have significant experience in HR, as I said, but just as a qualifier, sometimes the particular circumstances relevant to your business, we need to know that in order to provide you with appropriate advice. So general information only at this stage. And there is plenty of additional information available, particularly the Department of Employment and Workplace Relations website's got some good information on these changes at the moment.
And for everyone's information, we will also be sharing these slides after the presentation, in addition to the recording.
Yeah, thanks, Anil. So what will we cover today? Well, we're obviously focusing on the changes to the Fair Work Act, some of which have already commenced as at the 7th of December. And as I said, a number of the other changes will roll out over the period of the next 12 months. We'll identify what's happening and when as we move through the presentation. The changes, broadly speaking, relate to those items there, which we'll go through as part of the presentation. So I won't waste time by just listing those. We will, throughout the presentation and also at the end, give you some, what we hope is practical advice about what you need to start doing, what you need to start thinking about in order to meet your obligations as an employer. And obviously, we've got a Q&A opportunity at the end. Given the timing of today's session, we can't, we obviously hope it's of value, but the reality is it needs to be an overview of some quite complex legislation. So we're really focusing on the changes that have immediate effect, and we'll highlight the changes that are to come. And as I said, we will be providing some additional information throughout 2023 as further detail comes to hand. Okay, so the first area to cover really relates to job security and gender equity, which is a major focus of the relatively new government. So what's happening now? So one of the big changes that has come into being and is upon us is the prohibition of pay secrecy clauses. So as many of those that are on this call would know, it's quite common in employment contracts to include confidentiality clauses, which essentially prohibit people from disclosing their remuneration to other employees or others outside the organisation. Now, those provisions within contracts are now prohibited as of the 7th of December. So what that means, if you're bringing a new person on board, or you're varying an existing employee's contract, or you're issuing them with a new contract for whatever reason, you cannot have those confidentiality clauses in your contracts any longer. So however, for existing staff, you don't need to go and change their contracts. Those confidentiality clauses that might be in existing contracts pre-7th of December can remain, and they still operate. However, if for any reason you need to issue that person a new contract, or you need to vary their contract, you need to take out those confidentiality clauses. So what that basically means is that you cannot take any action against an employer that chooses to disclose their remuneration to any other employee or anyone else for that matter, nor can you prohibit employees from asking other employees of their remuneration details. There's not an obligation on any employee to disclose their remuneration details to another employee or anybody else. There's no obligation on the employer to publish anything in regards to remuneration. Essentially what the changes mean, though, are that an employee is entitled to disclose, and employees are entitled to ask other employees about their remuneration. So you know, that's quite an important change, and so at the moment the key thing is you cannot include those terms in new or varied contracts.
So Greg, can I just clarify something there?
Sure.
So obviously everyone has contracts now, and most may have this provision in there already in terms of you know, not allowing staff to disclose salary information.
Yeah.
So now that this has come in, are those clauses in existing contracts now void, or they still operate until a new contract is issued?
Yeah, for staff, for contracts pre-7th of December, those confidentiality clauses can remain,
right,
and they continue to operate. The only requirement in respect of existing employees is if you have to issue that person a new contract, or you vary their contract for any reason,
yep,
then you need to remove that term from any new or varied contract.
Okay, all right, thanks.
Yeah. Okay, so that's the pay secrecy stuff. So one of the other changes that has come in, which has less direct relevance, I'd suggest, to our audience, really relates to the inclusion of gender equality and job security as objects in the Fair Work Act. So what that essentially means is that the Fair Work Commission, when it's making decisions around minimum pay rates, variations to modern awards, for example, they need to consider issues such as gender equality and job security, in addition to the existing things that they consider, such as economic growth and productivity and general economic well-being. So they now need to, when they're making those decisions about minimum wages, for example, need to consider issues of gender equality and job security. So, you know, that won't have any immediate effect on most of our audience, but it will have impact on the Fair Work Commission's deliberations around award variations and setting of award rates of pay. The next thing relates to reforming equal remuneration provisions. So basically, this is to seek alignment between the federal and some of the state legislation in regards to equal remuneration related legislation. So the Commission will now be required to consider comparisons between occupations and industries where historically that the particular work relevant to that industry or occupation has been undervalued. So it just expands the nature of things that they need to consider when making those decisions. So again, it probably won't have any real immediate impact on most of the people in this audience, but what it will likely mean is that those sectors that have traditionally been seen to be low paying and predominantly staffed by women, that will begin to change, which of course is the government's a significant driver for the current government. So,
Greg, can I just add one
yep,
really minor thing to that,
please,
just in terms of those panels? I think one point that is important, which will make it really interesting when they start to set these up, is that in the past, the determinations have really been made by commission members with business and union input. There will be academics sitting on those panels, and that I think will add a whole new flavour to it.
Yeah, that's great. And those panels will commence in, but well, certainly by March next year. So again, that's all about compensating or improving pay rates for predominantly women's industries. So further changes to come in June next year is the right to request flexible working arrangements. So under current legislation, there are several groups of employees that have the right to request flexible work arrangements. So that includes parents or people that have care of a child who is school age or younger. It includes people that have carer responsibilities, people that have a disability, people that are 55 years or over. They have, under existing legislation, the right to request flexible work arrangements, and the employer is required to consider those requests and, respond to those requests. What the new legislation does, which commences in June next year, is that it expands the range of people that have that opportunity to request. So it includes employees who are pregnant, and it also includes employees who are themselves experiencing or they're supporting a member of their immediate family or household who is experiencing family or domestic violence. So basically, it just gives more people access to that right to request flexible work arrangements. So the changes extend beyond that, though, and what they also do is that they require an employer to set in place a fair and transparent process to consider requests for flexible work arrangements. So they're putting an increasing onus on employers to really seriously consider any requests that they receive for flexible work arrangements. And those requests need to be formally responded to by the employer. And there's certain grounds on which they can justifiably not agree to a request, but it's just sort of ramping up that onus on the employer to consider those requests and not just dismiss them out of hand, but give them genuine consideration. They also require, the changes also give the Fair Work Commission the opportunity to mediate and even arbitrate in relation to disputes around requests for flexible work arrangements from eligible employees. So basically, if you get a request from an eligible employee to have a more flexible workplace arrangement and you deny that request, you need to advise that person of the reasons for your denial of that request. You also need to advise them that they have the opportunity, if they so choose, to seek recourse of that decision through the Fair Work Commission. And then the Fair Work Commission will try and get the parties to mediate a suitable arrangement that is amenable to both parties, or in certain circumstances they will go through to arbitration, and the Commission themselves may well make a decision about whether that person has an entitlement to access flexible work arrangements. So the advice, I guess the practical advice around that is, if you do get flexible work arrangement requests from eligible employees, you really need to be considering them seriously. You need to have in place a clear process for considering those requests and responding to those requests. Our advice is, if you're in a larger organisation where you've got multiple managers and that sort of thing, is to really centralise that process so that you've got consistency in terms of how those requests are dealt with. Okay. So yeah, there's some significant changes there. Further changes to come in June 2023 is extending the unpaid parental leave provisions. So under current arrangements, employees that are on parental leave have the opportunity to seek extension of their parental leave for a further 12 months, up to a total period of 12 months, unless their partner's already taken 12 months of leave. So what the new legislation does is it increases the onus again on the employer to seriously give consideration to those requests and to respond formally to those requests and only deny those requests under certain circumstances. It also implements, again, a further level of appeal, if you like, of an employee whose request is denied. They can seek, they can pursue that issue through the Fair Work Commission, who again will mediate and in some cases arbitrate that matter. So again, it's sort of just ramping up the onus on the employer to consider those requests, and in effect it's giving an appeal mechanism to any denial of those requests through the Fair Work Commission. Okay.
There's just a point of clarification there, which probably can be covered now instead of the Q&A. Dell said that she thought that currently it's 12 months already. This is in terms of the unpaid parental leave provisions. So it's not extending the time available, the months available. It's more about the appeal process that they've strengthened.
That's correct.
Yeah, basically.
Right. Okay.
Yeah.
Right.
Yep. So it's just it's implementing more. It's making sure that employers are considering those requests perhaps more seriously than some may have done in the past, and it is implementing that sort of third-party appeal process.
Similar to the request for flexible working arrangements. I know it's a different topic, different issue, but it's more about employers now need to seriously consider it, show that they're considering it, and explain why they aren't allowing it if that's the case, and so on. And then there's a more of an appeal process through Fair Work that the employees can take up.
That's right. Yep.
Right.
That's correct, Anil. And the bottom line is that at the end of the day, if conciliation is unsuccessful, Fair Work can arbitrate. Mm-hmm. So the decision may be made for you.
Yeah. Okay. All right. Better move on, Greg.
That's fine. So those things happen in June next year. Also in June next year, the penalties commence for the breaching of pay secrecy provisions. So whilst that legislation is current now, the penalties won't kick in until mid next year. Mm-hmm. December 2023, commencement of provisions limiting the use of fixed term contracts. So under this arrangement, so basically what the government's trying to do is to implement more job security for more people. So there are some industries, there are some organisations where there's sort of a rolling fixed term contracts. The government's looking to remedy that where there's no real legitimate reason as to why they're fixed term contracts. For all intents and purposes, they're ongoing employment. So they're not outlawing fixed term contracts by any means, but they are saying that they can only be used in certain prescribed situations. And they are limiting those. So you cannot have, for example, more than 2 fixed term contracts, rolling consecutively, and you cannot have fixed term contracts for the same role for beyond 2 years, unless it falls within one of those categories where it's permitted to extend beyond that period. The government's also implementing a fixed term contract information statement. So most employers, hopefully on this call, would be aware that when you've got a casual staff member, you now need to give them a copy of the Fair Work Casual Employment Information Statement. They're now implementing a similar statement for fixed term employees. So when that comes out, probably mid next year or something, or towards the end of next year, you will be required to issue that statement to all employees under fixed term contract arrangements. The other thing to note with that one is that any existing fixed term contracts you have in place will count towards the 2-year limit or the 2 contract limit. So even though the legislation doesn't kick in until December 2023, if you've got existing fixed term contracts prior to that time, they will count towards that limit.
Okay.
Okay. Right. So now the next set of changes to the legislation relate to workplace bargaining, enterprise agreements, and those sorts of things. Now, we're just going to touch on these at this stage because they're not likely to commence until probably mid next year, potentially a bit earlier, but they're not current just yet. So what we will like, there's still a fair bit of grey in relation to these changes. So we will likely do another webinar February, March next year once we've got a few more details around this one. But we can talk in broad terms, however. And there's really quite significant changes here, and the nature of these changes are such that I think what we will see over the coming years is a significant increase in enterprise bargaining negotiations than perhaps we've seen in the last 5 or 10 years or so. And I think part of that is really the government really seeking to move forward on its commitment to increase pay rates, but also offer some flexibility for employees and employers to negotiate agreements. So there's going to be 4 bargaining streams, and you can see the names of them there. Cooperative workplace bargaining stream is the first one, and that's basically where employers, so multiple employers, can elect to enter negotiations with their employer groups and just do it as okay, well, we think this is a good idea, we think this is sensible, we think it's a good arrangement for the employers, we think it's potentially a good arrangement for employees. Let's have a chat, let's see what we can do. And so that's a genuine, okay, let's see if we can come to a better deal that suits us both. So that will be available from June 2023.
So that was where employers initiate that?
Yeah, and employers basically get together as a collective, hence the cooperative name. So they'll have some sort of a similar interest, but it might be, the Penrith car dealerships enterprise agreement, for example, where 5 get together.
Okay.
Okay, the single interest bargaining stream. So I guess an important thing to note with this one is that it does not apply to employers with less than 20 staff. So if you've got less than 20 staff, breathe a sigh of relief because this won't impact on you directly. And what it means is that unions or groups of employees could potentially seek to engage in enterprise agreement negotiations with employers if the bulk of employees in those impacted organisations express an interest in negotiating. So the bulk of employees want an enterprise agreement to happen, and there's a common interest between employers or organisations relating to that potential agreement. So a union, for example, could go to the Commission and say, well, we want to negotiate an agreement with this group of employers, and we think the bulk of employees in those organisations want that bargaining to occur. And then the Commission will consider that, and then if the Commission decide, well, yes, that seems a good idea, then employers that are relevant to that potential discussion will be required to negotiate in good faith with the unions or the employee representatives and see if they can come to some sort of arrangement.
So, Greg, in your previous example, it could be now the converse, where the employees of the Western Sydney car dealerships, for example, bandy together with their union if they have one, or just collectively somehow, and create some sort of enterprise agreement if the Commission agrees to it.
Yeah, well, the Commission would agree to the negotiation commencing, and then the employers would be required to begin negotiations in good faith. So it would not be possible for the employers that are subject to that sort of arrangement to say, well, no, we don't want to negotiate. They actually, there is a requirement on them to negotiate in good faith and try to come to some agreement.
Yeah. As long as those employers have 20 or more staff.
Yes, and well, the other hurdles are that the majority of employees in each of those organisations agree. Now, exactly how they demonstrate that, we're not quite clear just yet. That's one of the details that needs to be worked through. And it also needs to be a sensible collective of organisations. You know, they need to be obviously in a similar industry and or in a similar location. You know, it needs to be a sensible conglomeration, if you like, of employers. The other thing that's quite interesting with that, though, is that once an agreement is struck, the union can then go to other businesses and seek to have that enterprise agreement apply to them. So, and in the example that we used, if that initial agreement was struck between the unions and 5 car dealerships in Penrith or something, and then the unions decided, well, okay, it might be a good idea to rope in the car dealers in Blacktown, they could seek to do that. And those employers may be required to comply with the terms of that enterprise agreement.
And that's even though they weren't involved in the original negotiation.
Correct. Yeah.
Okay.
So that's quite interesting. It'll really be interesting to see how that one evolves. Yep, we've got to move on. So yes. Supported bargaining stream. So this is similar to the one that we were just talking about. The difference here is that they don't necessarily need to demonstrate that the employees agree. A union can just seek to start to engage with certain businesses to negotiate an enterprise agreement where there's some common interest between those employers. Now, where we see this one likely to be used is in lower paid industries and occupations such as childcare, disability services perhaps, and aged care, because one of the requirements for this particular stream, or one of the factors that may relate to this particular stream, is government funding. So the minister in this case also has the opportunity to say, well, I want this group of employers or this employers in this industry to start to negotiate an arrangement. And if the minister makes that declaration, then those employers are again obliged to start negotiating in good faith. The final stream is a single enterprise bargaining. So that's the traditional one. I guess that's the one that we sort of it prevails predominantly now, which is just a single entity deciding, okay, well, let's start to have a chat and let's develop an enterprise agreement for our business with our employees. Now, you can do that now. There's no requirement to wait until June 2023. And in fact, one of the things that we're likely to see over the next 6 months is some businesses taking a strategic decision to start to negotiate their own enterprise agreement, a single enterprise agreement, so that reduces the opportunity for them to be roped into other agreements down the track that they may not be party to negotiating, if that makes sense.
Yes. Yep.
Better off overall tests. So there are going to be some changes to the better off overall tests. So most of you are probably familiar with that. What that basically means is that when you do have an enterprise agreement or similar with your employees, it needs to pass this test. So basically, people under that agreement need to be seen to be better off overall than they would have been if they continued current arrangements under the award or whatever it was that applied. So the changes basically, they're a bit technical in nature, so I won't go through them all, but essentially what it does is it provides a bit more certainty to both employers and employees that the Commission will take more of a holistic view at the changes rather than looking at every individual item to see whether every employee is better off under each particular item. They'll take a more holistic look and decide, okay, well, yes, on balance, people will be better off under this arrangement. So,
okay, Greg. Now the next 2 points, do we need to cover those? I know I'm just conscious of time.
yeah. Look, no, I don't. I think we can leave those. They wouldn't apply potentially to most people, but just if you do have existing enterprise agreements within your business, I would strongly encourage anybody in the audience that does have an existing enterprise agreement to seek advice within the next 6 months about just what they're doing in terms of renegotiating or maintaining that arrangement.
Okay, good. Thanks. I think they're the main changes. There's a couple of other things that you want to cover off, but I think they were the big ones that I know has been in the media over the last few weeks.
Yeah. Okay, so we'll just touch on a couple of others then. So prohibiting sexual harassment. So some of you may be aware that a number of years ago, the government introduced some new provisions around bullying, workplace bullying, by which people could go to apply to the Fair Work Commission to have an order to stop the bullying issued. They're doing something similar now in respect of sexual harassment. So there will be an opportunity for people that feel they've been subject to sexual harassment to go to the Commission and seek some sort of remedy to have that addressed. Another important aspect of that, though, is that they're extending the eligibility for people to access that opportunity to have those things addressed. So it's not just sexual harassment of employees. We're talking about sexual harassment of potentially contractors, subcontractors, volunteers, and all that sort of thing. So they're really broadening the legislation to provide further protection for people there. So what we'd really suggest there is that it will really ramp up the onus on employers to seek to effectively address any concerns relating to sexual harassment in their workplace. So, we'd suggest strongly that you have some clear policies, you do some education, and that you have a clear process to address any concerns of that nature that may arise within your business. The next one relates to strengthening provisions against discrimination. So I think that in large part, this is an alignment of federal legislation with some of the state-based legislation around discrimination. So the federal legislation tended to have a shorter list, if you like, in terms of the personal attributes relating to discrimination. They're now expanding that list so that it's more consistent with state-based legislation. So it will be illegal to discriminate on the grounds of things like gender identity, intersex status, and breastfeeding. So they're just expanding that, and as I say, aligning it with state-based legislation.
Good.
We're not. Yeah, I don't suggest we spend much time on this, but there are also some legislation in train to abolish the Australian Building and Construction Commission and their responsibilities for legislating that or enforcing legislation in that industry. We'll just refer back to the Fair Work Commission in line with other industries. And the government's also abolishing the Registered Organisations Commission. Won't have much impact on people here, but it will certainly have some impact on unions and so on. Compliance and enforcement. So small claims, so they're making some changes which basically increase the opportunity for employees that are suffering from underpayments, for example, to have those claims heard in a quicker and less complex environment, if you like. So at the moment, employees can seek to access remedy for underpayments of a value of up to $20,000 through a small claims process. That's now expanded to $100,000. So basically, it just provides an easier remedy for people to seek redress if they're underpaid and so on. And it just streamlines the process somewhat and stops clogging up the Fair Work Commission. There's also some changes to prohibit job advertisements that breach Fair Work, the Fair Work Act. So again, I don't think that I wouldn't say that as being much relevant to our audience here, but certainly in some industries there has been a history of providing false or misleading information relating to remuneration in job advertising. So they're just taking action to get rid of that.
Very good.
Okay, so they're the key changes. Appreciate that we've gone through that pretty quickly. There's a lot more detail that sits behind it, but hopefully it just gives you a higher level of awareness. What would we encourage your business to do? Well, we would suggest that you review certain policies, particularly those that relate to the changes in legislation around sexual harassment, discrimination, pay, transparency, equity, and also flexible work. We'd really encourage you to spend some time looking at those, making sure that you're prepared for the legislation that has come in and will be coming in over the next 12 months. Obviously, once you've sorted out those policies, make sure that they're effectively communicated to new employees. Today, here and now, make sure that if you're issuing any new contracts of employment, that they do not include any pay secrecy provisions. And even if you've got existing staff to whom those confidentiality arrangements continue to apply, I'd strongly seek advice before you take any action against somebody that may have breached those provisions, even if they're an existing employee that has that in their current contract. Get ready for upcoming changes, particularly such as those relating to the flexible working arrangements, recognising that there's an expansion to the groups of eligible employees able to request arrangements, and there's an increasing onus upon employers to seriously consider those and be able to legitimately justify any refusal of flexible work arrangements. And again, just something I said during the presentation, we'd strongly suggest if you've got a larger business that you centralise that process so that you've got consistency across the business in terms of how you respond to those sorts of matters. And then finally, if you do currently have an enterprise agreement in your business or you've got one expiring, I'd strongly suggest over the next few months that you do reach out to somebody, seek some advice as to what you need to do to prepare for the future changes. Even if you don't have an enterprise agreement, we expect that some businesses will take this opportunity over the next 6 months to really give serious thought to, okay, do we want to negotiate an enterprise agreement with our team here and now so that eliminates or at least reduces the potential for us to be roped into an agreement down the track that we weren't party to.
Great. Very good. No, I think it's great to be able to, as you said, have a list of things that people can do now. Let's open up to Q&A. We have a few questions that have come through during the presentation and a couple just now. So Mark, a little bit earlier, asked if an employee's request to work from home would be regarded as a request for flexible work arrangements. Now, I responded in the chat saying, yes, I think so, as long as that they fall within those groups that you mentioned, Greg. I was interested to hear that over 55s is one of those groups.
Yes. Yeah, and I don't think a lot of people know that, frankly. But look, it's not open slather with flexible work. Not everybody has the right to request. But I mean, just from a cultural perspective and just a sort of, managing your team perspective, I think it's appropriate to give consideration to any request, but in a formal sense, only those employees in the groups that I've highlighted, which are now expanding, they have the formal right to request, and they have the right to an appeal potentially through the Fair Work Commission.
And working from home could be one of those requests. It could be varied hours, working hours, starting early, finishing early, those sorts of things.
Days and times of work, location of work, they're all flexible work arrangements.
Can I just expand on that a tiny bit? So our understanding, and it's very loose at this stage because this is completely untested at this point, is that the requirement is going to be beyond just no because it doesn't suit the business. There's going to have to be a need for discussion, potential compromise, so if the person says, well, I want to work from home 3 days a week, have the conversation around, well, maybe 2 will work or maybe 1 will work, those sorts of things, and document every single one of those conversations before it's just a no.
Yeah. And when I spoke to Greg about this yesterday, Margot, I also asked whether smaller business may have less ability to accommodate compared to a larger business. So Greg said that the employer's situation and the employee's situation would obviously both need to be considered as part of
Yeah, absolutely. And there are still legitimate reasons in the Act that you can say no. I think it's just going to be, it's important that you need to be aware that you will probably, if it's disputed, be more closely scrutinised in terms of the legitimacy of those issues for the business.
Yeah. Now, Greg, Faith has asked a question: will Fair Work have the compliance to pay secrecy in their employment templates? Because I know that Fair Work, the website, has quite a few of these templates. Presumably they'll remove that.
Well, I would expect so. Yes. Yeah. I'd be very surprised if I had a look at them in January and that there was confidentiality clauses in there. Yeah.
Another question is, I have a client in the dance industry who has staff on fixed term contracts. Would it be best to go into casual employment?
Well, look, I think we'd better, we'd need to better understand the reasons, I guess, for why are they fixed term. Certainly casual is the most flexible of all the employment arrangements. So that's something that could be considered, but there may be legitimate reasons as to why you've got fixed term contracts. So they're not banning fixed term contracts. They're just trying to cut out what I would suggest what I would loosely call sham fixed term contracts, where they're fixed term just because if all of a sudden we don't like the person, we can just not renew their contract. The reality is that happens, and the government's trying to get rid of that. But there are perfectly legitimate reasons as to why you might continue to have fixed term contracts.
So I suppose just looking through what you've covered, Greg, and Margot, these potential bargaining enterprise agreements is an area that could cause some people some concerns. Can I just ask a quick question? Does anyone, if you can just reply in your chat, does anyone here already have an enterprise agreement in place with their employees? And while we're asking that, Holly's asked, if a contract is fixed term because it's tied to a certain job site / contract, is it still okay? So that could be where presumably a business has won a contract and has staffed up to fulfill that contract, and obviously there's no guaranteed work after that contract. So Greg, I assume that would be a legitimate use of a fixed term contract for employees?
I personally think so, but we'd need to sort of consider that a bit further. I'm just trying to look at my notes here, because there is some prescription in the legislation around, what is a legitimate use of a fixed term contract. So that includes things like performing a discrete task for a fixed period. So that may well relate to I think you said it was Holly, so that may well relate to Holly's situation. apprentices and trainees undertaking essential work during a peak demand period, such as harvest or Christmas time might be another good example. Temporarily replacing another employee on leave, such as workers' compensation leave or presumably parental leave would be another example, or where people are earning above the high income threshold.
Okay.
But yeah, so there are legitimate cases, and that may well be though.
And just seeing the responses about my question about enterprise agreements, as we'd expect, most people don't have one. A couple have responded that they do have one, and one that's potentially very old and may need to be reviewed. Mark's also asked a question or statement. Moving forward, there will no longer be annual award pay rate increases, as has occurred previously, linked to the minimum wage increase. This is what we would not call cooperative bargaining moving forward, ? I'm not exactly sure what he means by that. I'm not sure if you can see that in the chat, Greg.
Yeah, I can.
But
yeah, I'm not entirely sure either, but I'm not aware, Margot. I'm not sure if you're aware, but to my knowledge, there won't be any change to the sort of annual minimum wage increase.
No, my understanding is that will still happen. It will just be reviewed by these expert panels who will be taking things like the gender equity components into consideration as well. So awards will continue to exist.
Yeah.
And remuneration increases on those awards each year, as I understand it, will continue as well.
All right, we better, any other questions before we wrap up, everyone? Now, Greg, I don't know if there's any other slides after this one. I think it's just...
I think it's just closing. So, yeah, you will receive a copy of these slides. Of course, reach out to Margot or I if you have any questions. When knocking off at the end of the week, of course, but back early January, and Neil's details are there as well, of course. So feel free to reach out if you need any further support. We do issue a newsletter every so often, updates, so we'll be providing updates to people through that as things become clearer in the new year. And as I said, we'll likely also do another webinar in the new year, particularly focused on the enterprise agreements, bargaining changes.
Holly's made a comment here. Thanks, guys. You're going to be busy reviewing all of our policies. So I suspect that's there will be a bit of work for both of you, and also obviously people in this. People may already have HR consultants they work with, but if not, obviously Greg and Margot work with a lot of my clients. I recommend them highly. So if you do want any further assistance, whether it's reviewing your current policies or just your circumstances and how it may relate, how this new legislation may relate to that and how you can apply it, then definitely get in touch with them. And as Greg said, that there will be more clarity around these changes over the coming months, and there'll be more information, whether it's webinars or other newsletters and so on. I know Greg and Margot issue regular newsletters with updates as well. So all of that will be coming your way. Otherwise, finally, just like to say thank you from me. Thank you to Greg and Margot in particular for pulling together all of this information. There's a lot of information to go through, and trying to condense it so that it's kept to around about this 45-minute mark. I know we started a little bit late, so well done, guys.
Okay, thank you everybody, and reach out if you need some help.
Yeah, thanks everyone. Have a great Christmas, everyone. Yes.
Okay. All right, see you all.
And if anyone wants to stay on and just have a chat, happy to do that. I'm just going to stop the recording and the screen share.